All right, so it's thank you for coming to today's seminar on uncertain sovereignty, the new Dominion constitutional framework, lessons from Pakistan. I'm David Law. I'm the Sir Y.K. Pao Chair of Public Law here at the University of Hong Kong, and it is my great pleasure to welcome two wonderful, popular, and prolific scholars working in the area of South Asian constitutionalism. To my immediate left is Dr. Mara Malagodi. At the risk of recapitulating what is on the flyers, she's a senior lecturer at the City Law School at the University of London. She is a comparative constitutional scholar who speaks an array of languages. Don't test her; it's quite embarrassing if you're on the receiving end of it. Specialized in South Asian law and politics, human rights law, legal history, and law and film, working in the law and literature area as well and offering new class in that area. She's the author of the monograph Constitutional Nationalism and Legal Exclusion in Nepal, published in 2013 by Oxford University Press, and numerous articles and book chapters on constitutional law and history, including a chapter for a forthcoming volume from Cambridge University Press entitled Constitutionalism in Context, which some of us are familiar with. And she will be presenting and then we have, speaking on uncertain sovereignty, Ceylon as a dominion. It's my pleasure to welcome Rehan Abiratne, who is recently arrived. He's an example of reverse brain drain, people coming to Hong Kong. He's an assistant professor at the Chinese University of Hong Kong, our prolific neighbors to the north. His research interests also include comparative constitutional law, human rights, and public international law. Prior to joining CUHK, Professor Abiratne was a scholar in residence at the Center for Human Rights and Global Justice at NYU Law School, and from 2011 to 2016, he was associate professor of law at the Jindal Global Law School in Delhi, India. So I believe the format will probably be, given the time, each of you speaks for 15 to 20 minutes, and then we leave a bit of time for questions at the end. That is amenable to everyone. So Mara, why don't we start with you?
Thank you so much, David, for the superb introduction, and thank you very much to the Center for hosting me yet again on another talk. I'm really excited to be talking about this with Rehan and to have David chairing this. So what I'm going to do today is two things. First of all, tell you a little bit about these projects, joint projects that we have on New Dominion constitutionalism, and then use the case study of Pakistan to illustrate some of the points with regard to the model that we are developing. So the question really that I think is interesting to grapple with is what's interesting here in looking at a fairly obscure constitutional model and constitutional period for comparative constitutional lawyers. So what can we learn from the in-depth investigations of a number of case studies? So let me give you a sense of what we're looking at in particular. So what we have for this project is a set of papers. The first one is by Professor Peter Oliver at Ottawa, looking at all dominions, so mostly Australia, New Zealand, and partly South Africa. We have a paper from a colleague of mine at City, Luke McDonough, on Ireland, which we define as the Bridge Dominion. And then we have really the three main case studies, which are the South Asian ones. The Indian one is prepared by Roy Day, who's at Yale. The Pakistan paper is by myself, and the Sri Lanka paper is by Rehan, here with me. We're now finalizing a joint framework paper, and that's where I'm going to start with. And that's also with Professor Thomas Poole at the LSE. So what we think here is that essentially what's exciting about all of this is this transitional model. So just to give you a sense of what we're talking about, for what concerns Ireland, we're looking at the years between 1922 and 1937. For what concerns South Asia, we're looking at, for India, a very short period under Dominion constitutionalism, which is between 1947, the year of independence, and 1950, when the permanent constitution was promulgated. For Pakistan, it's a longer period. It's 1947 until 1956, and for Sri Lanka, even longer, 1948, 1972. So what we're interested in is a focus on non-settler colonies. And the reason for that is essentially because of the two features of the model that we're interested in. First of all, in those case studies, Dominion status was always supposed to be a transitional model. It was never there to stay. It was something that was negotiated politically to usher those countries into independence and into responsible government. Also, what's important for us is the historical context from the point of view of Britain and from the point of view of Asian developments. So, of course, it's the end of World War II, so it's the difficulty of Britain to retain that part of the empire. And it's also the budding context of the Cold War, which is really significant, especially for some of the case studies like the Pakistan one. The claim that we make with regard to this project is that New Dominion constitutionalism really represents the first constitutional model designed to manage constitutional transitions on a global scale. So we argue that it's transnational and it's transitional. It's also, we kind of refer here to a lot of the literature that was essentially published after the end of the Cold War with regard to constitutional transitions. And we argue that actually what you need to look at starts at that point with regards to liberal constitutionalism. Also, this is the first part of the project, and we stop at the dominions. We are planning on moving on later on to Commonwealth realms. So what you see is that actually quite a number of former British colonies obtained independence on those bases, and just to name a few, we're talking about Ghana, we're talking about Kenya, we're talking about Uganda, Mauritius, a number of Caribbean states which remain Commonwealth countries, and so on. So really, we're looking at a particular set of features that we want to consider. It's also a critical juncture. So the point that we make is that those constitutional developments that took place in that time were really important with regard to the kind of constitutional systems that developed. So on the one hand, the Dominion Constitution offered an interim frame of government to manage a really difficult political transition, which is the transition from colonial dependence to post-colonial independence. And on the other hand, that period and the Dominion Constitution forms the legal basis upon which the new permanent, often Republican constitutions are drafted. So what struck us immediately was that when we designed the project, everyone thought we were being a little crazy, and that I was like, well, why are you focusing on this? Why is that relevant? So the first thing that we discovered is actually there is a lot of amnesia about the Dominion period, and you can see that quite wonderfully in Roy's India paper. And the amnesia is from the point of view of the decolonizing nation, because you have this idea that somehow Dominionhood was less than full independence, and you also have that from the point of view of the British metropolis, because on the one hand it was a loss of imperial control, on the other hand it really led to the transformation of the Commonwealth in 1949, when in April, in the span of 10 days, you have Ireland leaving the Commonwealth, and you have India remaining as a republic. So that really changed the legal nature of the Commonwealth and the legal nature of the Crown. The result is that, from a legal point of view, the Westminster Parliament passes the Royal Titles Act in 1953, and that kind of marks the legal end of Dominion status. So technically, Pakistan and Sri Lanka from 1953, they become Commonwealth realms. And then you see this kind of transformation in the changes to the new Commonwealth. Let me give you a preview of what we talk about New Dominion constitutionalism in terms of a model. So we argue that it's a constitutional mold of a particular kind that is being developed. So let me start with this idea of Dominionhood as a bridge between dependence, colonial dependence, and post-colonial independence. So let's start with what are the discontinuities from the colonial period. Well, first of all, of course, this is about responsible government for the former colonies. And how is that achieved? That's really the legal meaning of institutional independence, where you have a representative government which is responsible to an elected parliament on the basis of the British model. So what we have is a Westminster-derived majoritarian parliamentary form of government. What you have in Ireland, India, and Pakistan, it's also a parliament that functions as a Constituent Assembly as well, explicitly so for India and Pakistan on the basis of the Indian Independence Act. The second element of this continuity is the relationship between the national parliament and the imperial parliament. So what happens is that in the Act of Parliament passed by Westminster, the lawmaking independence of the former colonies is recognized in legal juridical terms. So you have a self-limitation of Westminster parliamentary sovereignty in the sense that the Imperial Parliament is no longer able to legislate for the former colonies. And that's, the example would be Section 6, for instance, of the India Independence Act. And that reflects the earlier position in law under the Statute of Westminster of 1931. So the question, you know, from the British point of view is, so is the UK Parliament still sovereign? To what extent can we deal with that? So those are the discontinuities, but what's striking about the model is actually the amount of continuities that remain with the colonial framework. So first of all, you have retention of the constitutional link to the imperial crown. The head of state is the governor general who represents the crown. We see in some of the case studies, especially Pakistan, that proves to be particularly problematic. Secondly, you have the retention of a strong executive at the center. So when we look at the representative element of government. So extensive royal prerogative powers, and the question really becomes how effective are constitutional conventions as a non-legal form of restraints on executive power in constraining executives which are very powerful by design and by nature. And you have the issue of elective dictatorship that, of course, persist. And that is, of course, a question that becomes important in all the case study, and it becomes really instrumental for nationalist leaders to support state building and consolidate and centralize state power in all of these countries. Third, and that will become particularly relevant in Rayan's paper, so I'm going to be very brief about that, is the retention of the Privy Council's jurisdiction as the highest court of appeal. What you need to notice is that that jurisdiction, for instance, in India and Pakistan is removed quite quickly in 1949 in India, 1950 in Pakistan. Fourth, you have an emphasis on the rule of law and an independent judiciary, but that's still within the framework, the British framework of political constitutionalism. So you have non-entrenched constitutions. So if you look at Pakistan, you see that the Dominion Constitution is amended quite frequently by the Constituent Assembly / legislature, and also none of the Dominion constitutions contain a separate chapter on fundamental rights. There is some discrepancy, I think, here with Sri Lanka, but Ryan will tell you more about that. And it's an emphasis on evolution and managed political and constitutional change through flexible, open texture and ambiguous constitutional structure, so very much in relation to the British Constitution. Also, there is no blueprint on the drafting of the permanent constitution, so that in a way allows quite neatly for local political actors to claim ownership of the constitution. So the idea is that the framework is quite so vague that it really becomes, is up to local actors to do so. So that kind of is a very brief sketch of what we think about when we theorize about this new Dominion constitutional model. So what about Pakistan? With regard to Pakistan, what I've done in my paper is to look at the Dominion Constitution. I'm not going to repeat a lot of the things I've said already, and I want to focus on the second part, which is the constitutional litigation over the dissolution of Pakistan's first Constituent Assembly. So I don't know if you know much of the story. By way of background, the first Constituent Assembly of Pakistan operated since independence up until 1954, when the clash between the legislature and the governor general, supported by the army and the civil service, really came to a standstill, and eventually by an exercise of the governor general's prerogative powers, the governor general dissolves via an emergency proclamation the legislature. So what's the issue here? The issue here is that the Constituent Assembly in the last move, just before being dissolved, had amended the Dominion Constitution, introduced jurisdictions, so it was eventually possible for the President of the Constituent Assembly to litigate the decision of the Governor General to dissolve the body. What do we have here? And that really, the argument that I make in the paper is that the Pakistani courtroom is really a Cold War theater. And what we see here, not just in terms of battles of legal ideas, it's also in terms of battles of legal actors. And I think that's interesting for students of Asian constitutionalism and students of British constitutionalism. So let me just give you an example of what you have in terms of actors. In the paper, I go into much more detail with regard to this, but just by brief overview, Sir Ivor Jennings, who's one of my long-term pet projects, as you all know, essentially was hired in '54 by the Constituent Assembly as the chief draftsman for the Constitution. So he actually had just been to Karachi before the body was dissolved. He returned to Sri Lanka because that's where he was posted, as he was the Vice Chancellor of the University in Ceylon, and is contacted by the legal secretary of the Pakistan's Governor General, and he receives secret instructions in his professional capacity as a barrister to essentially offer a legal opinion to the Governor General of Pakistan on the constitutionality of the dissolution. So if you look at Jennings' papers, you really get quite a sense of the story. And also you get a sense that he breaches the confidentiality of his client because he's reporting back to the British High Commissioner in Ceylon. And he shared the opinion, the legal opinion on the case with that. And that position is confirmed in the archives in the US and so on. So Jennings is involved in the litigation at first instance and in the federal court case. At federal level, so on the appeal, you have a second well-known British legal actor who's Diplock QC, Kenneth Diplock, later Lord Diplock, more famous, I think, for the juryless courts in Northern Ireland. And in his previous appointment, I think he was the secretary of a security intelligence committee for MI5 during World War II, appointed by Churchill when he was a young barrister. So someone with quite a close relationship, I think, with security forces and so on. On the other hand, the Constituent Assembly hires Dennis Noel Pritt, who was, well, a British MP for Hammersmith North, a well-known communist, and a very successful commercial law barrister. So, and not just that, Dennis Noel Pritt was considered possibly the most visible apologist of the Stalin trials. So quite an interesting mix of actors going on there. With regard to the legal issues, the question really becomes, what are the regulations of royal prerogative powers in the way in which they're exercised by the Governor General? What kind of conventions of kind of long-standing British constitutional convention apply, and to what extent? What's the issue? The issue is that the Dominion Constitution does not specify anything in the statute with regard to the dissolution of the Constituent Assembly. Simply, the statute is silent. So the argument is that the Governor General exercises inherent royal prerogative powers to dissolve the body. The interesting part becomes that Jennings realizes at appeal that the best argument that he could put forward is not quite so much the legality or not legality of the dissolution. Actually, he goes one step forward and he's trying to exclude the jurisdiction of the court. He's trying to say, well, the Governor General never assented to the amendments of the Dominion Constitution. So if we look at well-known British constitutional law precedent, it means that the courts don't have any jurisdiction at all to hear this case. So Jennings' arguments are rejected at first instance by the Chief Court of Sindh, and they're, however, accepted by the federal court in 1955. So you can imagine the country is in legal disarray. Quite a number of amendments to the Dominion Constitution are suddenly no longer good law. There's no legislature in place, and so on. You have two more cases in which the court tries to redeem itself. They say that, well, actually the Governor General cannot give the permanent constitution. They'll have to essentially call for a second Constituent Assembly. And then you have the final case, which is Special Reference 1, that using the doctrine of necessity, the court justifies the intervention of the Governor General and states that the dissolution of a Constituent Assembly, the first one, was actually lawful. So what do you have here? Well, you see that the initial tensions between Parliament and the executive is not resolved by the intervention of the courts, first of all. They don't, partly within that tradition of British deference towards the executive, the courts step back and don't really challenge in any way the executive intervention. But I think, I think my time is almost up, David, is it? Right. So I just a couple of small concluding points. I think when I look at Pakistan and I look at this through the frame of Dominion constitutionalism, what I think is interesting and what I think I've learned is that, well, rather than a Westminster legacy, which is really in place with regard to the executive-legislative relations, really what I see here is progressively a new role for the courts. What Parliament is trying to do in Pakistan, first of all, is to bolster the position of the courts. When you look at the draft that the first Constituent Assembly produced and then the constitution that the second Constituent Assembly eventually promulgated, you see that they actually are looking much more at Ireland, at India, and the US. That the model that they want to follow is not the one of Britain. That the idea is that, well, we realize the kind of executive legacy that we have in the country, and the idea is that we'd rather move towards more legal constitutional constraints. Of course, the experiment doesn't last very long, and in 1958 you have a military coup, and it's the first of the many bouts of recurring Praetorian rule in Pakistan. So I stop here.
So it's my pleasure next. Now we turn things over to Rehan Abiratne for his paper, Uncertain Sovereignty, Ceylon as Dominion, 1948-1972.
Okay. Okay. Good afternoon, everybody. Thanks very much for being here on what, as Mara said, is a fairly obscure topic. So we appreciate you all being here. Thanks very much to David for chairing this session, to CCPL and to HKU for inviting me, and to Mara for initially inviting me to write this paper. I've been sort of spending the last couple of years working on constitutional law in India for the most part. So this was a really nice opportunity for me to go back to some of the constitutional issues in Sri Lanka and look at it through this lens of Dominion constitutionalism, which I have to say I didn't know was a lens until Mara reached out to me. So I'm very glad to be a part of this. So this presentation is based on a paper that I wrote for this symposium, and it looks at Ceylon, which today we know as Sri Lanka, as a dominion, which was a dominion for much longer than many of the other South Asian countries. So it was a dominion from 1948 to 72. I'm going to assume that not everybody here is an expert on Sri Lankan constitutional history. So I've put together a PowerPoint, which I don't usually do, but I think because this is going to be quite fact-heavy, I'm going to rely a lot on that. And I'll start by introducing the Sri Lanka Dominion Constitution, sort of how it came to be, what its main features are. I'll talk about a couple of important cases from that period, one which has to do with fundamental rights, and another that has to do with constitutional structure. And I'll end by talking about some of the effects on global constitutionalism and Sri Lankan constitutionalism today. As Mara rightly said, I think one of the things that I found doing this research is that legal events and legal developments in the Dominion period have actually had really far-reaching effects, and it's gone beyond the subcontinent. So I'll end by talking about that. So a couple of words about dominions. Mara has already said most of this, but I'll just quickly recap a few things. So David McIntyre has this wonderful phrase calling it a halfway house between a colony and an independent state, and I think that's a really good analogy, in that it's almost like a sort of weaning off process for these former colonies, right? So they're British, and then they're kind of still British culturally, but they're slowly moving towards independence and are trying to kind of get rid of that dependency. So dominions generally are sovereign over their own affairs, but maintain the British monarch as the head of state. As Mara said, they also tend to imitate aspects of British constitutionalism and tend to, at least in Sri Lanka's case, hang on to the Judicial Committee of the Privy Council as the court of final adjudication. I think these dominions are interesting because despite sort of there being many dominions, I don't think this was ever theorized, at least at the time. And so sort of like many aspects of British constitutionalism, it just kind of emerged and developed organically around the world and took slightly different forms or avatars wherever it showed up. And so when we get to Ceylon, I think it's a really interesting case study because I think it is sort of halfway between, in some ways, the so-called settler or white colonies like Canada, New Zealand, or Australia, and the so-called tropical dominions of India and Pakistan. Obviously, regionally, it's closer to the tropical dominions, but I would say culturally, Sri Lanka is very different from India and Pakistan in that there is a small anglicized and largely Anglophile elite that was very, very influential in the negotiations towards dominion status. And in that sense, I would say it was culturally a little bit more like the settler dominions, at least more so than India and Pakistan were. And one of the things I say in my paper is that this was a mixed blessing, right? So on the one hand, you didn't have partition, and you didn't have the enormous social upheaval of Indian independence. On the other hand, there was no real move towards independence in Sri Lanka, so there wasn't a shared national identity that developed, and there wasn't a sense of indigenous constitution making that ever took hold. It was really imitative of Britain in every way, and down the line, this led to disastrous consequences, as I will get to in a minute. Just quickly about Sri Lanka's Dominion Constitution. So Sri Lanka became a Dominion on February 4th, 1948. Sir Ivor Jennings, again, he's everywhere, was the driving intellectual force. As Mara said, he was the Vice Chancellor of the University of Ceylon, and was a really sort of influential figure in that period. There's sort of two things I think that are worth saying about Sir Ivor's thought. One is that he wasn't a fan of what he called Indian-style entrenched rights. He was very much a Brit in that sense. He didn't like written constitutions much, and he certainly didn't like written constitutions with full schemes of fundamental rights. The other thing to say about Ivor Jennings is that in his early days, he sort of made a name for himself by distinguishing his own political thought from A.V. Dicey, who was the dominant constitutional thinker of that time. And one of the ways in which he did that was to argue that Parliament could be limited. Right? So Dicey famously in the UK said that Parliament was sovereign, and not just sovereign, but supreme in every way. And Jennings would say, no, actually, there can be what he called matter and form limitations on what Parliament can do. And he, I wouldn't say imposed, that's a little strong. He recommended that this should be the case for the Sri Lankan Dominion Constitution. And an example of that is that the Sri Lankan Dominion Constitution required a 2/3 majority in Parliament to pass constitutional amendments, and they had to do that whenever they passed a law that sort of changed the existing constitutional structure. And this would be a form of manner and form limitation. It wasn't a sort of strict limitation on what Parliament can do. It just switched the kind of format in which they could do it. They had to have that 2/3 majority. And as I say in the slide, the rest was left to convention, right? So this is the kind of British influence. There was only one rights provision in the Sri Lankan Dominion Constitution. It was section 29(2). And even this rights provision didn't really enumerate an individual right. It enumerated group rights. So it said that Parliament could not pass laws that discriminated against any religious or religious group or community at the expense of a different religious group or community. But it wasn't clear at the time, at least, that this could lead to an individual having standing or bring a case alleging a violation of section 29(2). Okay, I'm just going to give you a very brief history of Sri Lanka in terms of a political history, just so because I think it's important context for the cases that I'm going to discuss. So as I said, they left everything to convention, and one of the reasons they did that was Jennings and the British brass had a lot of faith in Sri Lanka's first prime minister, or Ceylon's first prime minister, who was named D.S. Senanayake. The joke at the time was that D.S. stood for Dominion status because he had fought so long to get Dominion status and was very, very trusted. The problem, though, was that D.S. Senanayake had a horsing accident, fell off his horse, and died 4 years after Ceylon became a Dominion. This left a power vacuum, which was then filled by, I would say, opportunistic politicians who sort of, whatever shared Ceylon identity was emerging, they demolished and played to ethno-nationalist politics and fears. So very quickly, Sri Lanka is a pretty diverse place, but there are 2 or 3 big communities that have often and regularly been in conflict. So the majority population is the Sinhalese population, which is roughly 80% of the population. There is a significant Tamil minority, which is about 12 or 13%, I think, of the population. And then there's a significant Muslim majority as well, minority as well, which is about 8 or 9%. And what Bandaranaike, who was the next prime minister, or one of the next prime ministers did, was to play to the fears of the Sinhalese majority and say, look, you have been denied kind of nationhood and your identity has been suppressed for all these years. I am going to bring us back to a kind of glory period of Sinhalese nationalism. And of course, that was done at the expense of the Tamil and the Muslim minorities. As a result of this, Westminster conventions that were developing under Senanayake and that Jennings and the folks that negotiated Dominion status hoped would develop were completely thrown out the window. And so eventually, though it took a while, Sri Lanka became an independent republic in 1972. And in that intervening period, many laws were passed that I would say were blatantly discriminatory. And what I'm going to show here is that the courts didn't do much about it. And one of the reasons they didn't do much about it is that they saw themselves as operating in a environment of parliamentary supremacy because they were so imitative of the UK, when in fact that wasn't the situation in which they were in. So let me begin with fundamental rights because that's easier to get a handle on. So both the Ceylon Supreme Court, which is the highest court in Ceylon at the time, and the Privy Council, in my view, were unduly deferential to Parliament in this period. I think the best-known case is the Kodeshwaran case from 1967. This case challenged the constitutionality of the so-called Sinhala-only Act, which was the most controversial of the Sinhalese nationalist policies that were passed in this period. Basically, the Sinhala-only Act made Sinhala, which was the majority language, the only official language in Ceylon. Aside from the kind of symbolic aspects of this, where the other languages, including Tamil, were not considered on an equal status, it was also discriminatory in practice because you needed to speak Sinhalese, or Sinhala, to get a government job. And this was actually directly targeted at the Tamil minority, who were overrepresented in government jobs at the time. And so what happened in this case was there was a Tamil clerk who worked for the government who spoke Tamil and spoke English, but did not speak Sinhalese, and was required to sit a Sinhalese proficiency exam to keep his job. And he refused to sit that exam, saying that this discriminated against him on the grounds of Section 29(2), which, as I mentioned, said that Parliament cannot pass a law that discriminates against a particular group or community. To me, this was a pretty prima facie case of discrimination, but the Ceylon Supreme Court didn't really touch it altogether. They went into a very long description of the difference between Roman Dutch law and British common law. I'm not sure why they did that, but there was a sort of a long discussion on the history of Sri Lankan law, and then they finally get to the issue, and then they say, well, we are noting the, quote, reluctance of the American and Indian Supreme Courts to decide constitutional questions, and so we are leaving it at that. And so they didn't address the issue at all. So Kodeshwaran, the petitioner, appealed this to the Privy Council, who said, well, we don't know much about Ceylon, so that's fine, pretty much. We're going to uphold this as well. And what you see in the reasoning, in my view, is a lot of references to British cases, which were very, very deferential of Parliament, which was appropriate in the British context because Parliament is sovereign in the UK. Parliament was not sovereign in Sri Lanka, but they nonetheless took these precedents and misapplied them in Ceylon. As I say here, the Ceylon Parliament was not supposed to be sovereign like the British Parliament was. The Dominion Constitution wasn't clear about this, but it wasn't the understanding of Jennings, certainly, or the folks that were drafting the Constitution that it would be treated like this. But for some reason, the Sri Lankan judges and the Privy Council didn't look at it this way. I'll now move on to talk about constitutional structure, which is a little bit more complicated, but I think sort of paints a similar picture. So, on these issues, the Supreme Court of Ceylon was a little more deferential, while the Privy Council was more activist. I have activist in quotes both because it's a loaded word, but also because it was perceived to be activist in a way that was not received well, let's say, by the Sinhalese nationalist authorities. So many of the cases that arose in this period related to the power of the Ceylon Parliament to create independent tribunals. The Solberry Constitution vested the judicial power in the courts of Ceylon. And so the question was, could Parliament simply pass laws creating new tribunals that had judicial power, or something like judicial power? They could try individuals, they could sentence individuals. Could Parliament do that without amending the Constitution, right? So one of the few limitations on Parliament is that if they wanted to amend the Constitution, they had to have a 2/3 majority to do so. What happened in a lot of these cases, though, is that Parliament said, no, we're sovereign. We're like the British Parliament. This doesn't really apply to us. This is kind of a guideline. And we are just going to pass whatever we want to pass. And so one of the more contentious cases that arose under this area was the Bribery Commissioner versus Rana Singh case. So the Ceylon Parliament passed an act called the Bribery Act, which created tribunals that would try and convict government officials. It was later expanded to also include some private individuals, but it was mostly government officials who were accused of bribery or corruption. But Parliament didn't amend the Constitution to do this, so they were essentially vesting a sort of judicial power in these tribunals without having amended the Constitution to do so. The Supreme Court upheld the act, and it's not a particularly interesting opinion, but the Privy Council reversed. And this actually is interesting. So Lord Pearce, who was sitting on the Privy Council, said that there was a plain conflict between the Bribery Act and Section 55 of the Solberry Constitution, which vested the judicial power in the courts of Ceylon. He also made clear, in case there was any sort of concern of this kind of neo-colonialism, that the Privy Council was just following the rules, right? This is just a manner and form limitation. He said, no question of sovereignty arises here. Parliament could pass this act. They just have to follow the rules in the Solberry Constitution. They have to do so by a 2/3 majority. So far, so good. I think this was absolutely correct as a matter of law. And the tone up to this point was also, I think, appropriately respectful of the fact that Ceylon was moving towards being independent. Then Lord Pearce decides to just throw in some dicta for no good reason whatsoever. And this dictum is probably the most famous, I would say, piece of any Sri Lankan case that's ever been decided. And it was just in this sort of, it was a throwaway sentence in the background section of his opinion, where he's referring to Section 29(2), which is that one fundamental rights provision in the Solberry Constitution, which prohibits religious and communal discrimination. And he said the following: these provisions, that is, the rights protecting provisions in Section 29(2), further entrench religious and racial matters, which shall not be the subject of legislation, all fine. They represent the solemn balance of rights between the citizens of Ceylon, the fundamental conditions on which inter se they accepted the Constitution, also okay. And here comes the problematic part, and these are therefore unalterable under the Constitution, right? This suggests that there is a substantive limitation on the Ceylon Parliament's power to pass laws, which was immediately interpreted as an absolutely unacceptable colonial intrusion into the powers of the Ceylon Parliament. So this Rana Singh was actually one of the rallying cries of nationalist politicians towards the end of Dominion status. So they said, look, you know, we can't have cases like Rana Singh. There was another case along the similar lines, which said something similar, that they also used. And they said, look, this is a foreign intrusion into our sovereignty. We should be able to pass our own laws. How can the Privy Council say that some aspects of our Constitution are unalterable? That isn't what we signed up for. And the effects of this, I mean, it's not a sort of direct correlation, but this was one of the factors that led to Sri Lanka adopting a republican constitution and ending Dominion status. As I say here, it also had lingering negative effects on Sri Lankan constitutionalism. I trace a little bit in my paper the way in which the Sri Lankan courts have never assumed the kind of prominent role that the Indian courts have, and certainly the Indian Supreme Court has. They've never been particularly rights protective. They've never been particularly structurally independent. And it all started in the Dominion period. And I think a lot of it is because in the Republican constitutions, the power of judicial review was narrowly defined and really constrained out of a fear that independent Sri Lankan courts would be like the Rana Singh Privy Council bench, that it would be this kind of out-of-control entity that impinged on Sri Lankan sovereignty and sort of parliamentary supremacy. Just very quickly, because this is interesting and, you know, broader than Sri Lanka, one of the things that Lord Pearce's dictum about unalterable aspects of the Ceylon Constitution did was to play a role in the formation of the basic structure doctrine in India. So as you might know, Keshavananda is a sort of famous Indian case in which the Chief Justice Sikri at the time and some other justices held that there are aspects of the Indian Constitution that are immune from constitutional amendment. These are sort of the core aspects or the core identity of the Indian Constitution. And if you look at Chief Justice Sikri's opinion, where does he get the idea for this? Lord Pearce and Rana Singh, right? And as I say, Lord Pearce was wrong. Not only was he wrong, it was dicta in sort of a background, in sort of the background of a case. But you know, the basic structure doctrine is now a fixture in global constitutionalism. Our friend Yaniv Roznai just wrote a brilliant book about it, which I think was presented here. And I mean, not to put too fine a point on it, but it may not have ever existed had Lord Pearce not written a stray sentence in a random opinion about a small dominion 50 years ago. Thank you.
Excellent. So I think there's plenty of food for thought here. On the one hand, we have raised for us the question of the efficacy of constitutional conventions. Of course, the Brits, why put something in writing when you can leave it unwritten, right? How effective are, and this is perhaps of particular relevance, a question raised by both of these papers for Hong Kong, how effective are constitutional conventions, especially with respect to restraining powerful executives, and are there conditions under which reliance on these conventions can succeed? I'm sure we're all familiar with the argument that was made until recently that the National People's Congress was bound by a constitutional convention not to issue interpretations of the basic law unless requested to do so by the Hong Kong government, and we see how long that lasted. The other question, though, raised, I think, more acutely by Rayan's paper is that if you do resort to a system of judicial enforcement, how efficacious are those restrictions, right? So it may be that one of these approaches works better. Just these two case studies of countries that are otherwise in so many ways so similar suggest that neither family of mechanism is especially effective, which leaves us with the question of whether it is appropriate at all to focus, or we should be focusing on these mechanisms, or whether there is something that these countries share in common as new dominions that led to the collapse of these parchment barriers. That's a lot to throw out there, but I don't know if I may be exercising my chair's prerogative here to frame those questions at the outset, but we can also take some questions from the audience. Alex Schwartz. Oh, do you want to push your mic button? Yeah. He's...
Good. Okay, so I think it is for both of you, but it starts with Mara. So you said, you used the term critical juncture at the outset of your presentation. And my question is about the added value for your analysis of that term. So when you say critical juncture, it triggers, at least it triggers for me, certain expectations about what the analysis is going to do. So that as I understand the term, it's not just an important moment of change, it's a particular kind of moment of change where, for whatever reason, some previous structure is open for options for development in different directions. So there's a choice, there's a menu of choices perhaps at that point. But that whatever choice is or choices are made then have downstream path-dependent consequences for, so they restrict or structure subsequent choices and development later on. And so I was a little bit, maybe I'm just not clever enough, but I was a little bit straining to see precisely that mechanism at work in what you were talking about. So it can't be that what happened with the transition to the new Dominion constitutional framework was just an inevitable sort of path. So it has to have been, in some sense, you know, some choice was made. But then the things that happen afterwards have to be sort of structured by that choice. And is your argument that there is a kind of commonality across these new Dominion constitutional frameworks in terms of how that structures subsequent development? Or is it just that for all of these different places, a different path-dependent trajectory seemed to take root and follow its course at that transitional moment? And I wasn't really clear which of the two it was. Or maybe I'm just taking the term critical juncture too seriously. So I would appreciate your help on that.
Alex Green.
Yeah, thanks very much. That was super interesting. And my question is kind of linked to that. So, Mara, you mentioned that part of this model is the model that you're using to explain across these various examples is that domestic political actors have a lot of space in which to make choices. And I wondered if you could talk a little bit more about that structurally. Because you both went into quite a lot of detail in these particular examples as to how that panned out. But again, it's a commonality point, whether there's something that sits across them all that speaks to that opportunity for political action and what form it tends to take and how it's enabled.
We let our illustrious panel digest that round of questions, and then we'll see if there's more.
Can I start with Alex's questions on critical juncture? So yes, we're still working on that because we're still finalizing the final paper, but I'm using the critical juncture in an institutionalist sense in relation to path dependency. So I haven't just thrown it in there willy-nilly. So the idea of how were they restricted, I think, what the commonality has been across the case studies is a question of executive dominance, which is in part inbuilt into the Dominion Constitution with regard to the relationship between the executive and the legislature. And the way in which that's played out in the different context, of course, it's not been the same. But even take India and Pakistan, which possibly are the best examples to compare. Because on the one hand, you have the same kind of Dominion Constitution for both countries. What we're saying, if we start from the India paper, what was instrumental about the executive dominance was really the construction of the state, for instance, what the Dominion Constitution allowed for. First example is the assimilation of the princely states. So it's the idea that it's very much at the center of state building on the one hand. With regard to Pakistan, what you have again a centralizing tendency. So you have both federal structures in both countries, but you have in both case studies quite a clear development in that direction with regard to centralization. With regard to executive-legislature relations, again, quite similar, again, on the basis of the British model. We need to do a little more on that, I think. It's still part of one of the unfinished parts of the paper. Alex, your questions about the space to make choice, opportunity for political actors, and so on. One of the things that to me is interesting is the debate over the inclusion of fundamental rights in the constitutions, and of course, especially if you look at the Indian Constituent Assembly debates, there were debates that started well before independence itself with regard to the Charter, the section of fundamental rights. With regard to Pakistan, the idea of including them and in what form also became quite relevant with regard to the construction of the national identity and in relation to Islam and how they would fit or not. David, your question was on limitations.
Yeah, my question was, both of these mechanisms seem to fail, both the conventions and enforcement of a constitution. So the question is, if we go up a level and look at new dominion countries as a category, is there something about these countries in particular that will explain why both mechanisms would fail? Is there something, in other words, can we say something about new dominion countries as a category rather that tells us about the efficacy of these kinds of mechanisms? Or is is there nothing distinctive about Sri Lanka and Nepal, and we're merely seeing that constitutional conventions fail, as in Hong Kong, and that also judicial enforcement of constitutions fails, as in see a whole long list? See a whole long list.
Oh, see a whole long list, yes. Oh, you want me to take that? Okay.
Either one of you. I think it's really for both of you.
Okay.
All right.
I can say a couple of things. Let me say something about executive power and then come back to David's question, because I think that's really interesting. I think Mara's absolutely right that one of the things that is common to the tropical dominions is the centralizing tendency of executive power, which is not something that I wrote about, but it was very much a legacy of the British Governor Generals in those places who had a lot of, I would say, almost unchecked power. I mean, a good example of that, even though we didn't talk about it, would be the Indian president's power to issue ordinances, which are basically legislation. And Shubhankar Dham, who until I think a month or two ago was at CityU, has written a really good book about how presidential legislation, as he calls it, or ordinances, is basically the primary way that major legislation is passed in India now, completely circumventing Parliament. And this is a legacy of the Government of India Act 1935, which allowed the British governor to do that. And I think Pakistan has had similar laws. I don't know enough about Pakistan. And Sri Lanka is very similar. In the Dominion period, the Governor General was a local person for the most part, as in not a British person. But they maintained many of the prerogative powers that the British governors had. And I think in both cases, and I think this is true in India as well, what we see there is then a sort of gradual decay or erosion of constitutionalism because of this unchecked executive power. And then it takes slightly different forms based on political culture. So in Sri Lanka, it took the form of ethnic conflict and ethno-nationalism. But it then led to a switch to the presidential system because it was felt that the parliamentary system that they had was not sufficiently empowering for the executive. In Pakistan, it's led to many coups, Bangladesh as well. And in India, it's led to this kind of fake legislative system where the president is legislating for the country without anyone really knowing about it. So that kind of gets to a couple of these questions. On David's question, I mean, I actually don't really know. I think this gets to the sort of, a question that I always struggle with, which is how much of any of this is institutional and how much of it is political culture. And I don't know. I guess I'm a fan of written constitutions just because I think it's good to have a court that's involved. I think India has been a relatively successful example of that. And I think the fact that it had the shortest dominion period is not a coincidence. That is to say, the fact that it could develop its own constitutional model that was largely, not completely, but largely inclusive and was able to empower its judicial institutions may result to a degree from the fact that it only had a 2-year dominion period. And I think that compared to its neighbors, it's done a much better job kind of maintaining democratic norms and some basic level of constitutionalism. I mean, Pakistan, Bangladesh, and Sri Lanka have been really not, wouldn't you say, sort of democratic or anything close to that for much of their independent histories.
I wanted to add one point, and I think if I look at the Pakistan example, what you see essentially is that through the decisions of the court, a vestige of legality is maintained. So if you even, and that was a comment I think that came up in some of the archival material, I think it was the US ambassador to Pakistan that commented that it was desirable for the controversy to be resolved by the courts in that way because it preserved the local legality. So my sense was that the constitutional structure kind of remained in place, but it was hollowed out from within. So there was still that cloak of legality that with a written, entrenched constitution you really wouldn't be able to have. And to me that was just the simulacrum of constitutionalism, to put it in Okotogendo's terms. It's constitution without constitutionalism. Really, I think that's the position.
Who are you quoting?
Okotogendo.
Oh.
So that's kind of my impression, and that was one of the things that kind of bothered me in my conclusions about Pakistan and what didn't work and why the Dominion Constitution failed. That, you know, that degree of flexibility worked only up to a point. And also the fact that there was no sanction on the part of the court somehow further legitimized that kind of executive intervention and kind of normalized it. So I think that's what's problematic about this set of Dominion constitutions. And that I think in India it was so brief, as Rayan said, that even if some of the decisions were problematic in those years, and even if effectively, to kind of go back to some of the earliest questions by Alex and Alex with regard to executive dominance, for instance, in India, Rohit has argued that a lot of the powers, security powers of the state or the colonial state were retained by the independent government, and they were used essentially to repress political opposition. And that was one of the ways in which the state was built, for instance, that kind of use of executive powers.
Interesting. I guess that you know, it must be the case on the one hand that it's difficult to have constitutionalism without constitutionalism. It's difficult to have the right political culture without the right political culture, but then the problem is, of course, the chicken or the egg problem. And I think, Rehan, your suggestion that maybe a shorter period of having the training wheels on might be one factor which gets us out of the circularity problem. I think we have time for another question if there is time. Otherwise, I hope that our panelists will have time to chat with us more informally afterward. Are there any other questions from the audience? Yes, Roberto.
Thank you. I listened to with great interest, and I would say that you started a new interest on my own. I wish I had time to become a student also of Dominion constitutionalism. Whatever I'm not going to do, I wonder if you are going to do, and these are two questions. The first question is, Rehane mentioned that Dominion status has never been theorized. Are you going to do it as one of the outcomes of your research? Because that might be interesting, although of course it may be not such a priority in terms of historical needs, but certainly from a comparative law point of view, it will be extremely interesting. Also, considering that in particular, you may try to combine some sort of focus on common law constitutionalism, but also on Asian constitutionalism, which might be very promising perspective. The second question may sound quite out of place, but I wonder to what extent you are considering the United States Constitution, and even more, the constitution of some of the founding states, Massachusetts and the like, as common law constitutions, Now, of course, we are in a different environment, but still, I think it will be extremely interesting to trace the common law origins of US constitutionalism, mainly, I repeat, at state level, but also at the federal level. This will be a sort of tertium comparationis that might prove to be helpful in finalizing this research. Thank you.
Thanks, Roberto. What are we going to theorize it? Well, we're still working on that, so we're taking the lead, Luke, Tom, and myself, and then I think the paper is going to go to our other project partners. So we're working on that. Short answer. With regard to extent of reference to the US experience, Peter Oliver has dealt with it in his paper. So it might come back in the final framework paper in a way or another. But definitely, you know, with regard to constitutional models and constitutional borrowing, the US and Ireland and, you know, India for Pakistan later on become quite important models. So I think one of the things that we're learning is that actually there is quite a lot of aversive constitution making with regard to Britain. That what you see in Ireland, in India, than in Pakistan is actually much more going down the American way. So, you know, that's been one of the considerations that we had, and we even wondering whether, in a way, the UK is going full circle, has been going full circle, and kind of imitating former colonies or even the old dominions with the passing of the Human Rights Act, and whether, you know, there are some lessons to be drawn here, but we're still in discussion on that point.
I hope we can all join in thanking Rehan and Mara for this wonderful seminar and for taking the time to trek all the way from the UK and from the new territories. But Mara had start on you. I think she started from closer. But thank you so much for this. I think everyone really enjoyed this. It was very, I found this to be very informative and thought-provoking. Thank you.